Yeah, so welcome to the session. So there are four of us speaking. So I'll speak first on it's basically on how the Supreme People's Court serves and safeguards the Greater Bay area strategy. Then second will be Jenny Fung from the Department of Justice. So speaking from her, so as a person who's been involved in negotiating a number of arrangements with the mainland, most recently the one with on matrimonial matters. Yes, so we have the person with real experience. Second, Edward Liu, a partner at Hagen and Partners. So speaking about the mutual enforcement of judgments arrangement and the arbitration related arrangement. So where do I go? Oh yeah, sorry. Oh yeah, Professor Zhang, hold on. Professor Zhang from Sun Yat-sen University from Zhongshan Daxue. So he's speaking on Zoom on conflicts of laws issues. Yeah. So hold on. Do I go? Yeah, so I can go up there. Alrighty. Okay, let me timers so I don't go over. Right. Hold on. Yeah, so I guess the official title of my presentation is Updates in Judicial Cooperation, but I flipped it to be how the Supreme People's Court serves and provides safeguards for the Greater Bay Area strategy. Hold on, what is this? Hold on, how does the next slide is here? Okay, so my it's basically 3-point roadmap. Oh, so why is the Supreme People's Court or the SPC serving the Greater Bay Area strategy, and how are the SPC and lower courts doing that, and a bit about the content of the strategy. So a lot of the other content will be presented by my fellow panelists. Okay, yeah, so why is the Supreme People's Court serving the GBA policy and Belt and Road policies? Because wherever the national strategy is deployed, the judicial service and safeguards of the People's Courts will be there. So it's the Greater Bay Area is an important national strategy, and therefore the Supreme People's Court needs to do its part in supporting the Greater Bay Area strategy. Yes, so this is Vice President Wang Yangming and many others have said this when announcing various services and safeguards opinion. Okay. Oh, it's not moving. Yeah. No response. Can I do it on the? Okay. Yeah. So how does the Supreme People's Court does it? By some of its unique functions. So one very important one is creating judicial policy. That's a lot of what I'll talk about today. So hearing cases not so important. So creating quasi-legislation, that's not an official term, but creating judicial interpretation. So those are guiding the lower courts and cooperating with other institutions. So next slide. Yeah, so how is it being, how does the Supreme People's Court implement the Greater Bay strategy? The principle is horizontal coordination and vertical implementation. So so the quotation at the bottom part of the screen is from comments by Judge Xian Li, who's the deputy head of the research office and the person who's leading Hong Kong, Macau related judicial matters at the Supreme People's Court. So she said, the successful signing of the supplementary arrangements on arbitration is due to the strong guidance of the Legislative Affairs Commission of the Standing Committee of the NPC, the following way. The Hong Kong Basic Law Committee, the Hong Kong and Macau Affairs Office, the State Council, and other relevant central authorities, as well as the strong support of judicial and legal circle. So, so this gives you an idea on the Chinese side that what the Supreme People's Court is doing involves a lot of horizontal coordination. Yeah, so on the creating quasi legislation, as also another quote from Judge Su's remarks, she says the effective implementation of the supplementary arrangement in the mainland needs to be transformed into a judicial interpretation. Yeah, and then on the Hong Kong side, it needs to be passed as an ordinance. Yeah, so the arrangements that my co-panelists will discuss on the Chinese side need to become judicial interpretations so that they can be a source of law for local judges. Okay, yes. So the following is a list of the principal Greater Bay Area policy documents. So they're implementing, related party and government documents. So the first one is the opinion concerning the provision of judicial services safeguards for the construction of the Guangdong, Hong Kong, Macau Greater Bay Area. I'm not sure of the year. Full text is unavailable, and it is it's an internal document. So I'm thinking perhaps it's related to the framework agreement, but I don't know. But it's not transparent. A number of the other ones are transparent. The November 2020 opinion on making Shenzhen a pilot demonstration zone. Yes, I won't bother to read the wrong title. So that's linked to the General Office of the Central Committee and the State Council for making Shenzhen a pilot demonstration zone. Yeah. So next slide. Okay. Yes. So some more. So there's a January 20. So January of this year. So there's a opinion on supporting and guaranteeing or safeguarding the construction of the Guangdong Macau in-depth cooperation zone in Hongqing. So it's also publicly available, linked to a related Central Committee / State Council document of September 2021. Similar one, but for the relating to the Shanghai, Shenzhen, Hong Kong one, also the same time period, related to a Central Committee State Council plan for deepening reform and opening up the Shanghai, Shenzhen, Hong Kong modern service industry cooperation zone. Yeah. And then, so for anybody who's interested in this area, I recommend reading the June 2020 report of the People's Court Servicing and Safeguarding the Construction of the Greater Bay Area 2019-2022 is publicly, full text is available on that one as well. Yeah, so what are some of the takeaways? So there are kind of two branches. One is focused on the domestic courts. A number of reforms are contained in those documents. One is authorizing the Shanghai courts to take cases without an actual connection, which is a current requirement under the civil procedure law. From my other reading, it's piloting possible future reforms to Chinese civil procedure law, so seeing how that works in practice before it actually gets incorporated sometime in the future into Chinese civil procedure law. Yeah, as was mentioned this morning, so letting, so Hong Kong Macau funded companies use non-mainland law as governing law of contracts. So it's encouraging like a one-stop mechanism for cross-border commercial IP cases. There's a centralization or of first instance Hong Kong Macau cases, also with the use of Hong Kong Macau assessors. This kind of centralization means, having a dedicated group of judges hear that kind of case. It can be dedicated group of judges, it can be a dedicated court in a particular area. So let's say Shanghai in Shenzhen, Shanghai could be designated to be the court to hear first instance case, Hong Kong Macau cases, within the Shenzhen area. So Shenzhen is the pilot for natural person bankruptcy and pilot for other reforms in insolvency or bankruptcy matters. Also, it mentions coordination among the authorities on the mainland. There's a lot of repetition of provisions in other of these opinions, such as treating private business equally with state-owned businesses. So next, so cross-border takeaways. So work further on establishing interregional judicial assistance. And so consider an electronic platform for civil and commercial judicial assistance in the Guangdong, Hong Kong, Macau, Greater Bay Area. So that means like the service of process and obtaining evidence. The service of process piece is mentioned generally in the mainland civil procedure law. So the establishment of a unified qualification recognition system for Hong Kong, Macau mediators to practice in the GBA area. I think that's already in place. Involving more Hong Kong, Macau legal experts as China International Commercial Court experts. So that's happened in the last group of experts that were appointed to the China International Commercial Court, with 5 involving more Hong Kong and Macau legal experts as advisors to the Guangzhou IP Court. I have no idea there how it's working in practice. And so a big thing is improving, insolvency or bankruptcy cooperation. And then we have that, Yeah, so it's not an arrangement, it's a kind of meeting minutes from last year. Yeah, so next. Yeah, and then Greater Bay Area provisions also appear in other Supreme People's Court documents. Yeah, so this is the 2019 document on providing judicial services and safeguards to the Belt and Road initiatives. Yeah, so it mentions that the development of Hong Kong as a regional legal service and dispute resolution center shall be further supported. Cooperation between HKI, so Hong Kong International Arbitration Center, and mainland institutions shall be increased, and that HKIC shall be added to the one-stop dispute resolution platform. So that finally happened in June of this year. Yeah, so again, the more expert members shall be added to the CICC expert committee, and Hong Kong shall play a more important role in the development of Belt and Road initiative. I think this is linked to this December 2017 arrangement between the National Development Reform Commission and Hong Kong as our government for advancing Hong Kong's full participation and contribution to the Belt and Road initiative. Yeah, so next. Yeah, so Hong Kong, yeah, so basically like the same, a lot of the same content appears in the September 2020 Supreme People's Court document as well, on serving and guaranteeing the further opening to the outside world, except that this one mentions Hong Kong and Macau lawyers be supported to participate in dispute resolution as mediators, and then the pilot program for Hong Kong legal practitioners to become Greater Bay Area lawyers. Yeah, so this is the vertical part that I mentioned a little while ago. Yeah, for the vertical implementation, the Greater Bay, there's a Greater Bay Area special working small group, the 专项工作小组. So jointly composed of the relevant Supreme People's Court Department and the Guangdong Higher People's Court. Yeah, and then there was, I guess, this, what else is related? Oh yeah, but I think this is, there are discussion minutes, or I'm not sure how DOJ has translated it, the Huitanjiao with Hong Kong and Macau on judicial and legal exchanges and cooperation. And there's a 2019 Guangdong High Court and Department of Justice arrangement on Greater Bay Area legal exchange and mutual cooperation. Yeah, but not all of these. I can't find all the documents. Yeah, so going on. Yes, let me see. There's so one thing mentioned there is judicial legal rules, convergence or harmonization, and a mechanism harmonization. Yeah, so there are various measures. Yeah, to improve the Guangdong courts and involve Hong Kong and Macau various areas. So 3 arrangements in 1 judicial assistance document with Hong Kong. The Hong Kong arrangements were very thankfully often preceded by public consultation, but I have a clip here from the consultation paper from several years ago. This is really brilliant if you're doing research on these things, because the Department of Justice explains each clause, not seen on the mainland side. Yeah, there are 2 arrangements with Macau. It doesn't seem they do consultation, but I'm less familiar with things on Macau's side. Okay, yeah, so next. Pardon? This work. Let's see. Yeah, so there are more things to come. Yeah, so per these discussion minutes, vigorously promoting mutual recognition, cooperation, insolvency, and bankruptcy. Yeah, so investigate. So that means to look into. That's at an earlier stage of improving service of process and obtaining evidence through an electronic platform. Yeah, more language about promoting arbitration and mediation. Yeah, and language about more exchanges, research on cross-border issues, and judicial internships for Greater Bay Area lawyers. You know, I guess that was concluded pre-COVID. Judge in an academic article that she published, it'd be February this year. So she mentions, so she's the article was on diversified dispute resolution, so a lot on GBA mediation issues. So she mentions, you know, kind of eventually a kind of Singapore mediation convention. That's the Convention for Mutual Enforcement of Mediation Agreements, having that kind of arrangement to make it possible for cross-border enforcement of mediation agreements. But this is Judge wearing her, whoops. This is Judge wearing her quasi-academic hat. So she's not, it's not an official statement of Supreme People's Court policy, but it's indicative of Supreme People's Court thinking, or at least, you know, her thinking. Okay, anything else? Yeah, sorry. Yeah, so I've listed articles I've written on sort of related to the Greater Bay Area, and yeah, so for those who read Chinese and are interested in this area, I highly suggest reading anything that Judge Xian Li publishes, because she's the one leading the negotiations on Hong Kong issues. Very, you know, she thinks about these issues a lot, you know, very thoughtful articles. So thank you very much. I'll go back to chairing the proceedings. Yeah, so I'm very honored for Jenny Feng to follow me. Yeah.
Yeah. Thank you, Susan. Thank you for having me. Just as Susan just introduced me, I was involved in the legislative process of this ordinance, and I explained the bill before the Bills Committee of the Legislative Council, and it's very happy now that it has come into operation. What I will do today is to give an overview of the background leading to this ordinance, the main provisions, and also the benefits that this ordinance will bring. The background. In 2017, the Supreme People's Court and Hong Kong government, Hong Kong SAR government, signed the arrangement on reciprocal recognition and enforcement of civil judgments in matrimonial and family cases. And this ordinance, the CAP 639, is to implement this arrangement. And this ordinance took effect on the 15th of February this year. The main provisions of this ordinance. There are three main components of this ordinance. The first component is to enable registration and enforcement of mainland judgments in Hong Kong. Second component is the recognition of mainland divorce certificates in Hong Kong. And the third component is the facilitation of recognition and enforcement of Hong Kong judgments in the mainland. First, we talk about how we register a mainland judgment in Hong Kong. The mainland judgments given in matrimonial or family cases in mainland can be registered in Hong Kong under the ordinance. The scope of it includes dispute over divorce, dispute over invalidity of a marriage, dispute over annulment of a marriage, dispute over division of the property of parties to a marriage during the subsistence of the marriage, dispute over property after divorce, dispute over matrimonial property agreement. Some more examples. This ordinance covers dispute over spousal maintenance, custody or maintenance of a child, custody or maintenance of child arising from cohabitation, access, guardianship, parentage, order for the protection of a person. And note is that adoptions in the mainland will continue to be governed by Section 17 of the Adoption Ordinance. So this part of the ordinance, this part of the adoption ordinance will remain intact and unaffected by this new ordinance. If you want to register a mainland judgment under the ordinance, you have to have the mainland judgment has to contain the specified orders. There are three main categories of specified orders. The first is status-related orders. Just as the name relates to the status of the parties. Examples are orders granting divorce, annulment of marriage. The second category is care-related orders. Examples are orders in relation to the custody or right of access, etc. And the third category is maintenance-related orders. For example, orders in relation to maintenance of a person, spousal maintenance, division of property between the parties to a marriage. So these are the three categories. If you have a mainland judgment containing these three categories, specified order, you can register that mainland judgment in Hong Kong. Application for registration. If you have a mainland judgment containing a specified order, you can make a registration application to the district court, family court in Hong Kong. And the specified order has to fulfill three criteria. First, it is given in a matrimonial or family case. Second, it is given on or after the 15th of February. That is the commencement day of the ordinance. And it is effective in the mainland. When can a registration application be made? For status-related orders, generally, registration can be made at any time after the mainland judgment has become effective. For care-related orders and maintenance-related orders, generally, they can be made within 2 years, subject to district court's permission to grant an extension of time. And how the 2 years is counted depends on the type of order. For example, if you have an order that specifies a particular day for compliance, for example, the payment of maintenance on a specific date, then your time limit will be 2 years after a default of payment. And if the order doesn't specify a date for payment, then normally it would be 2 years after the effective of the order of the judgment. Setting aside application. This setting aside application fulfills a very important function. It provides effective safeguard to the rights of the parties. If a party applies for registration, the other party will be entitled to apply to set aside the registration if he can satisfy the court that there are grounds for setting aside. The grounds, what are the grounds? These are examples. For example, the respondent was not summoned to appear according to the law of the mainland, or he was summoned but was not given a reasonable opportunity to defend. The mainland judgment was obtained by fraud. Recognition or enforcement is manifestly contrary to public policy. When the order involves a person under 18, the court must take into account the best interests of the person. Also, if the mainland judgment has been reversed or otherwise set aside pursuant to an appeal or a retrial, then these are if you satisfy one of these grounds, you are entitled to make a setting aside application, and the court will consider the merit of it. It is a requirement for registration that the mainland judgment is effective. And how do you determine whether it is effective? It means the mainland judgment is enforceable in the mainland, and the mainland judgment is either given by the Supreme People's Court, or is a second instance judgment given by the higher People's Court or an intermediate People's Court, or it is a first instance judgment given by the higher, intermediate, or the primary People's Court. And according to the mainland law, there is no appeal is allowed, or if an appeal is allowed, the time for appealing has expired. If the court is dealing with an application for setting aside, and in the process, an appeal against the mainland judgment is pending, or the case is ordered to be retried, then what should the Hong Kong court do? The Hong Kong court would need to adjourn the setting aside application to enable the process to take its course. So after the mainland appeal or retrial has been disposed of, then the Hong Kong court will can deal with the application for setting aside, depending on the result. When adjourning the setting aside application, the court may impose terms that it considers just. This is what we call the interim relief. This is for purposes of maintaining the status quo during the period of adjournment, ensuring the welfare and best interests of the person under 18, and preventing an irremediable injustice. Effect of registration. What is the effect of registration? For status-related orders, the order is recognized as valid in Hong Kong. For care and maintenance-related orders, they are enforceable in Hong Kong as if the order is given by the Hong Kong court on the day of registration. So the effect would be like you are having a Hong Kong judgment. You obtained a Hong Kong judgment. So you can proceed immediately to enforce it. So the second component, I'm coming to the second component, is the recognition of mainland divorce certificate in Hong Kong. If a party to a divorce obtained a certificate for divorce in the mainland, he can use the mainland divorce certificate and make an application before the district court, family court, under the ordinance. And like any other matrimonial and family case judgment, the other party can apply to set aside the recognition order if you can satisfy the grounds for setting aside. The grounds for setting aside are the divorce certificate was obtained by fraud, it is invalid, or the recognition of which will be manifestly contrary to public policy of Hong Kong. And the effect of registration is that the divorce certificate, the divorce specified in the mainland divorce certificate would be recognized as valid in Hong Kong. So you don't have to start a new proceedings. You just have to register. Now I come to the third component of this ordinance. That is, if I have a Hong Kong judgment, I want to enforce it in the mainland. It usually happens when the defendant has assets in the mainland. So the other party, the party obtaining the judgment wants to grab hold of the assets in the mainland. So he has to register the Hong Kong judgment with the mainland before he can start his enforcement action in the mainland. A party to a Hong Kong judgment may apply to the relevant court which gave the judgment for a certified copy of the Hong Kong judgment if it is given in a matrimonial or family case, given or after the commencement of the ordinance and is effective in Hong Kong. So it's like a mirror image. You can register a mainland judgment in Hong Kong. On the contrary, you can also register similar Hong Kong judgment with the mainland. And in order to do so, you can apply for a certified copy plus a certificate from the court, certifying that your application, your going to be application in the mainland would satisfy the criteria of the ordinance. So these procedures appear to be relatively simple. You apply for a certified copy of the judgment plus certificate, and you follow the procedures set out in the arrangement. And you can apply to register your Hong Kong judgment with the mainland court. What are the judgments which can benefit from this ordinance? These are examples: a decree absolute of divorce, a decree absolute of nullity, maintenance order, transfer or sale of property, adoption order, declaration relating to parentage or legitimacy of a person, injunction granted under the domestic and cohabitation relationship violence ordinance. So these are examples which can benefit from the ordinance. An order in relation to custody, these orders made under the various ordinances are included as part of the valid judgments, Hong Kong judgments, which can utilize the mechanism under mutual recognition and enforcement. These are the matrimonial causes, the guardianship of minors ordinance, separation and maintenance ordinance, matrimonial proceedings and property ordinance, and in respect of a person under the age of 18 years, he has been made a ward of court. So under these circumstances, it satisfies the criteria. And one highlight I would like to emphasize here is an order in relation to custody includes an order for the return and delivery of a child who has been wrongfully removed to the mainland or wrongfully retained in the mainland. This is a highlight because before the commencement of this ordinance, when a party gets a Hong Kong order, he gets the custody of a child, but the other party to the divorce unlawfully brings the child across the border to the mainland without and deny access of the person who has been granted access to the child. And before the ordinance, it's very difficult for that person to enforce that order of access. And if you want to, if you know that the child is in the mainland, you have to start a proceeding in the mainland. But now, under the ordinance, if you have a Hong Kong court order granting access of the child, you can use that judgment and register the Hong Kong order with the mainland court. And you can benefit from the coercive powers of the mainland court to compel the return and delivery of the child. So this is a very powerful tool. The benefits of this ordinance. Before, for enforcing a Hong Kong judgment in Hong Kong, you have to do it under common law. And you have to prove the mainland judgment is final and conclusive. And very often you need expert evidence from China law experts to provide an expert opinion that the judgment is final and conclusive under the mainland law. So this process can be lengthy and costly. And if you want to enforce a Hong Kong judgment in the mainland, you need to commence a new action in the mainland. This is the before situation. And as I have explained, there are a lot of hurdles. If a party encounters a situation where a child has been wrongfully detained in the mainland. So after the commencement of the ordinance, these situations have greatly enhanced. Under the ordinance, you don't have to provide expert evidence. You just need a certificate from the Hong Kong court certifying that the judgment is given in a matrimonial or family court and is effective. And this is prima facie evidence subject to a rebuttable presumption. So under the ordinance, it provides a clear legislative framework, and the process is relatively simple and less costly. And also, you don't have to relitigate. You can just register your Hong Kong judgment. You don't have to start a new action. So to many is a blessing, because if you are a Hong Kong party, you have to instruct a mainland lawyer to relitigate. It would be a headache, sometimes a headache to the party. Now, the mechanism is relatively simple. And also, it provides better protection to the parties, as a Hong Kong order in relation to custody includes an order for the return or delivery of a child who has been wrongfully detained in the mainland. So the benefits are a lot, and it's only the ordinance only commenced half a year ago, and we are studying the cases, and we hope this ordinance will give parties, will be more user-friendly to parties experiencing divorce or encountering disputes in a family or matrimonial situation. So in all, the arrangement and the ordinance enhance cross-border mutual legal assistance in matrimonial and family cases by alleviating the need for parties to bring separate lawsuits in the courts of Mainland and Hong Kong for the same dispute. It enables them to obtain timely and effective judicial reliefs and more effectively protect their rights. And it saves time and cost and reduce emotional stress. Thank you.
Okay, it's my actually a great pleasure to be here with this distinguished panel members here. And also thank you very much indeed for the Hong Kong University Law Faculty to invite me to join today's conference or seminar. And my topic today is actually basically talking about how to enforce the Mainland award and the judgment in Hong Kong. Of course, the arrangement is for the mutual benefits of both jurisdictions, but because of the limit of time today, I will only talk from one side, i.e., as I mentioned, the judgment and awards from Mainland to be enforced in Hong Kong. And I think the sequence of our panel speech is very good, because Susan actually, probably many of you actually knows that she is one of the top advisors to the Supreme People's Court, the China International Commercial Court. So what she just shared, the views are, I would say, authoritative. Then you can understand more about, why from a very high level, top level, the arrangement has been done between these two jurisdictions, and the benefits given to Hong Kong and of course both also Mainland. And then we have just heard the views from Jenny talking about the arrangement on the family cases between the two jurisdictions. And as she just mentioned, she was involved in the legislative process of that arrangement she just mentioned, and also the arrangements that actually I'm going to talk about. So her view, if not authoritative, but at least very persuasive, because we have heard the person who is working in the Department of Justice and talking about, how the ordinance is working. And as a practicing lawyer, then as a lawyer, the views shared by me is actually nothing. It's neither authoritative or persuasive. So it's just introductory. So I will not focus on, going through each clauses of the ordinance or pretend to be very authoritative on this arrangement that I'm going to talk, but basically let you know what are these arrangements about and how do they benefit Hong Kong to make Hong Kong as the international legal and dispute resolution service sector. So two parts of my presentation. First is applying for enforcement of the Mainland laws in Hong Kong. And the second part is talking about the enforcement of Mainland judgments in Hong Kong. And because of today's conference name, we start the conference name as One Country, Two System, and then with the cross-border legal harmonization. So I think it would be beneficial for us to see why there are cross-border jurisdictional assistance between these two jurisdictions. And for example, as Susan mentioned, why there are, the Mainland China and Hong Kong authorities can discuss this arrangement, and also like the DOJ, how could they, the basis for them to do it. So I quote these two paragraphs here. First, actually, is from the DOJ's website, is to pursue the objective of the effective implementation of the one country, two systems principle. The DOJ has taken steps to develop mutual legal assistance between the Mainland and Hong Kong SAR, so that disputes with cross-boundary elements could be dealt with more effectively. So that is the purpose, one of the purpose or major purpose for doing so. And for this arrangement, all the arrangement between these two jurisdictions to be made, it has the constitutional foundation, not only the legal foundation, legal basis. It is Article 95 of the Basic Law, which provides Hong Kong may, through consultations and in accordance with law, maintain juridical relation with the judicial organs of the other parts of the country, and they may render assistance to each other. So this may answer, I think, Susan, your question, why the arrangement on the civil and commercial judgment has been consulted in Hong Kong, but not for the arrangement between Hong Kong and Macau, because it says HKSAR may, through consultation and in accordance with the law. So I think it is within the discretion of the Hong Kong government whether they want to make the consultation with the public or not, and then to make the relevant arrangement to be effective. That's my, again, interpretation, which is not persuasive and authoritative. So first, talking about the enforcement of mainland awards in Hong Kong. Actually, the arrangement concerning the mutual enforcement of arbitral awards between the mainland and Hong Kong that was signed in 1999, that's probably the very first arrangement signed between these two jurisdictions. And from that time, making Hong Kong be a more attractive, I would say, the arbitration venue for the disputes relating, or I would say the China-related disputes. And of course, back to more than 10 more years, that arrangement proves to be, first of all, very useful. But secondly, there are quite a number of issues making the practitioners and of course also the court difficulties in enforcing the awards in Hong Kong. So in 2020, 2 years ago, a supplemental arrangement on the enforcement of the actual awards was signed and then became effective in I think in the same year. The next year, actually, because you can see the ordinance named the Arbitration Amendments Ordinance 2021. And under the arrangement and of course the ordinance, there are basically two major changes. First is the removal of the restrictions on the enforcement of mainland awards under Section 93, allowing parties to enforce their awards both with mainland courts and the Hong Kong court at the same time. So that is the supplemental arrangements clause. And you would imagine what was the issue with the original arrangement is that for the winning party to enforce an award, he must choose whether he wants to enforce the award in mainland China or in Hong Kong. And because the time limit of the enforcement in the two jurisdictions are different, in Hong Kong, you have 6 years to enforce the award. Either it's a domestic award or the award from mainland China or international from the other jurisdictions. But in Hong Kong, in mainland, you have 2 years. And there was indeed one case causing the problem because the winning party was trying to enforce that award in Hong Kong and spent quite a few years, and later realized that despite he received that judgment, the enforcement order from the Hong Kong court, but Hong Kong has no access to satisfy the damages. So the winning party turned to mainland courts, tried to apply for the enforcement of that award, but it found it already time barred. So under this supplemental arrangement, nowadays, whether it is Hong Kong award or mainland award, there's no need for you to choose. You can apply to enforce award in both jurisdictions concurrently. Of course, you cannot recover more than what you were awarded, right? If you're awarded 100, you cannot apply to both courts and seek for the separate 100, but in total 100. And you need to explain to the court that actually, despite you are applying, for example, the mainland court for enforcing the award, but it's not sufficient to satisfy the awarded damages, and therefore you are applying to the Hong Kong court for the rest of the money. So that's the very significant change of the supplemental arrangement. Secondly, it repeals the list of recognized mainland arbitral institutions published under Section 97 of the Arbitration Ordinance. the reason is still being the case that in Mainland, if you know arbitration, you must know Mainland doesn't recognize the ad hoc arbitration. If you want to commence arbitration, you must commence within an institutional arbitration or arbitration institution within Mainland. But in Hong Kong, or because of the development of arbitration, nowadays it's not really necessary to enforce the parties to must stick or adhere to a particular arbitration institution. And therefore, especially for the Hong Kong side, it is more beneficial actually for the Hong Kong side because quite a number of arbitration cases in Hong Kong, especially for the shipping cases, for the maritime cases, it is ad hoc arbitration. And therefore, it has removed the requirement or the list of the recognized mainland arbitral institutions. The benefit is that later I will explain, but I can tell you now that if, for example, the foreign parties choose to arbitrate in Mainland, but without an institution, without an arbitration institution, it will have less worry about whether that award can be enforced in Hong Kong or not. And basically, I would say it will be enforced in Hong Kong, as long as it, of course, satisfies the relevant conditions under the ordinance. So let us see why I would say the arrangement on the enforcement of awards is the most successful arrangement between these two jurisdictions, between Mainland China and Hong Kong. For the first 10 days of the original award, you can see that there are about or more than 94% of Mainland awards were successfully reinforced in Hong Kong. And there were totaling 84 applications to enforce Mainland awards in Hong Kong. And 18 respondents sought to set aside the enforcement order, and only 5 were approved, i.e., it was set aside to refused by the Hong Kong court to enforce the Mainland award. And from 2009 to 2017, the percentage of the successful cases has increased to more than 96. And there were 85 applications to enforce Mainland awards. And in the same time, for the overall applications to enforce awards, whether it is Hong Kong award from Mainland China or from the other jurisdictions, were about 250. And you could see the Mainland awards occupies the majority of the total applications. And there were only 11 applications were sought to set aside the enforcement order, and 3 were granted by the Hong Kong court. So the key takeaways, first of all, is that Mainland awards are very likely to be enforced in Hong Kong. So I know for today's audience, most of you are the academics or students. And if it is before me, the enterprises that come from the business sectors, I will encourage them actually, no matter whether you choose to arbitrate in Mainland China or not, welcome as long as you find the other side has a site in Hong Kong, come to Hong Kong to enforce it so that lawyers can have more business. And secondly, the close cooperation in trade and capital between the Mainland and Hong Kong has given rise to a series of civil and commercial disputes. And that's because we can see the application, despite that was only 8 years, and the application numbers to enforce the Mainland awards are already more than the first 10 years. Yeah, so that's definitely proved that actually the business relationship has been closer and closer between these two jurisdictions. And the losing parties have properties available for enforcement in Hong Kong. That means more probably Chinese companies have business, have presence, have assets in Hong Kong. So that's the reason why the winning party would consider to enforce awards in Hong Kong. And last but not least, Hong Kong is the most popular venue to enforce awards for Chinese parties to international arbitration and cross-border disputes. So that's again make Hong Kong to be the most popular venue for China-related arbitration or dispute resolution. So I will very briefly talk about the basic procedures for applying for enforcement of Mainland awards in Hong Kong. Basically, that's applicant shall submit application to the Hong Kong court, that is a court of first instance, and leave granted to enter judgment. That means the award becomes enforceable. And if the application dismissed, with leave can appeal to the Court of Appeal. And once leave is granted, the enforcement order will be served on the party subject to enforcement, i.e. the debtor of that award. And then the debtor may raise objection within 14 days, during such period of objection, the award cannot be actually enforced. The implications on the enhancement made to the arrangement, I mean both the original arrangement and the supplemental arrangement. The parties to arbitration proceedings seated in Mainland China and administered by a foreign arbitral institution, whether it is valid in Mainland China or not, will have less vary about when it comes to the enforceability of the arbitral award in Hong Kong, as the supplemental arrangement will apply to facilitate such kind of enforcement. And there are assets available for enforcement in both Hong Kong and Mainland. The winning party in whose favor an eligible arbitral award is made will no longer have to choose between the two jurisdictions and will be able to apply for parallel enforcement in both jurisdictions. And certainly, the parties to an arbitration seated in Mainland China or Hong Kong may apply to the relevant courts for interim measures, both before and after the arbitral award is made. The risk of dissipation of assets pending enforcement of the arbitral award is more manageable. In here, I would say, because I didn't have a chance to elaborate more today, the most important arrangement entered into one of the most important arrangement entered into in the past 5 years is the arrangement on the interim measure in aid of the arbitration between Mainland China and Hong Kong. And that making Hong Kong to be a very unique jurisdiction which can apply for the parties in Hong Kong, comply the interim measures to the Mainland court to freeze the Mainland assets, okay, of the other side. Because only Hong Kong, well, not only Hong Kong now, because Macau also has such kind of arrangement. But let's say for the most important arbitration centers worldwide, only Hong Kong has this benefit. And under that arrangement on the interim measures, that talking about before and during the arbitration, i.e. before you commence arbitration and during arbitration proceedings. And under the supplemental arrangement, from now on, you will have, I mean, the applicant normally have the whole picture, whole process to secure his claim if the other side has the assets to be enforced or to be frozen in Mainland China. Because after you get the award, and when you try to apply that award for enforcement, you can also apply for the interim measures from either the Hong Kong court or Mainland court. The second part of my presentation is talking about the enforcement of Mainland judgment in Hong Kong. The previous mechanism, it is, I would say, the choice of court arrangement. The arrangement was entered into between the two jurisdictions in the year of 2006. And then it became the law, the domestic law in 2008. And the restoration of Mainland judgment must meet the following statutory requirements, which I will not repeat here and you can see, but I highlight the third one, sorry. Oh, one more minute, okay, sorry, I cannot finish my second part actually. And the exclusive jurisdiction clause, that is the hurdle for the parties previously to enforce the awards in either jurisdiction. And now we have the new mechanism, the new arrangement signed 3 years ago, and very happily that we have this new law just passed by the Legislative Council last month. And I've just checked with Jenny that is the DOJ is working very hard to make it effective. And let's hope it can be effective very soon. And upon the relevant judicial interpretation to be issued by the PRC through People's Court, and the new arrangement will then become effective very quickly, Suzanne. The key features, I will simply skip it, but just I would say the removal of the exclusive jurisdiction requirement is no longer there. And there's no need for the parties to agree on the exclusive jurisdiction clause when signing the agreement, as long as the judgment meets the other basic requirements under the new arrangement. For example, if you have seen, just one more minute. Yeah, sure. Okay, Professor Zhang, just wait me just 1 minute. If you previously, if you have the contract, the jurisdiction clause would say, the party A, no more, right? Okay, sure. That's it. Okay, and the PPT is available, and if you want to receive it, you can check with the law faculty and get it. Okay, thank you.
Okay, it's my turn now. And thanks, Susan, for your moderation, and thanks for Hong Kong U and Professor Zhao Yun's invitation. My topic is about resolving the conflict of law issues in civil and commercial matters in the GBA. It is widely acknowledged that although the mainland, Hong Kong and Macau are all parts of China, they belong to 3 distinct jurisdictions with different civil and commercial legal systems. When it comes to a dispute involving 2 or more jurisdictions in civil and commercial affairs, the question of which jurisdictions civil and commercial law should be applied emerges, and the issue of inter-regional conflict of laws in civil and commercial matters necessarily arises. As the Guangdong, Hong Kong, Macau, Greater Bay Area construction continues, the conflict of laws in civil and commercial affairs between the mainland Hong Kong and Macau become an increasingly significant concern. The GBA's construction is not only a new attempt to support the formation of a new pattern of comprehensive opening up in the new area, but also a new practice to advance the cause of 1 country, 2 systems. As a lively world-class city cluster, the GBA serves as the demonstration zone for deep cooperation among the mainland Hong Kong and Macau. However, as stated in the outline development plan for the Guangdong, Hong Kong, Macau, Greater Bay Area, and 1 country, 2 systems, Guangdong, Hong Kong, and Macau have different social systems and legal systems. They are separate customs territories. Market connectivity needs to be further improved, and an efficient flow of factors of protection has yet to be achieved. In this context, it is undeniably of greater practical significance to explore the approaches to resolving conflict of laws in civil and commercial matters in the GBA. Neither the constitutional law nor the 2 basic laws make specific provisions for resolving inter-regional conflicts of laws in civil and commercial matters. Moreover, there are currently no unified rules of inter-regional conflicts of laws in China, nor have the mainland, Hong Kong, and Macau formulated their own inter-regional conflicts of laws. Regarding the resolution of international conflicts conflict of laws, the practice in the mainland has long been to treat civil and commercial relations involving Hong Kong and Macau as those involving foreign countries and apply the rules for settling international conflicts of laws by analogy. It is expressly stipulated in Article 17 of the Interpretation of the Supreme People's Court on several issues concerning application of the law of the People's Republic of China on choice of law for foreign-related civil relationships. That issue concerning application of law in connection with the civil relationships involving the Hong Kong Special Administration Region and the Macau Special Administration region are subject to these interpretations by analogy. Hong Kong and Macau, in contrast, deal with inter-regional civil and commercial conflicts of law in full accordance with international civil and commercial conflicts of law. Nonetheless, both basic laws provide that the special administrative region may, through consultation and in accordance with the law, maintain juridical relations with the judicial organs of other parts of the country, and they may render assistance to each other. Okay, I think everybody knows that, so I will pass that. In September 2021, the CPC Central Committee and the State Council issued the Master Plan of the Development of the Guangdong-Macau Intensive Cooperation Zone in Hengqin. We call it Hengqin Master Plan. The Hengqin Master Plan clearly states that the advantages of the principle of one country, two systems shall be fully leveraged, and the civil and commercial affairs regulatory system that matches with those of Macau and aligns with the international criteria shall be established step by step, and the premise of observing the Constitution and the basic law of the Macau SAR. Also, the Hengqin Master Plan further mentions that the judicial exchange and collaboration between Guangdong and Macau shall be enhanced, and a well-established diversified mechanism of commercial dispute resolution consisting of international commercial litigation, arbitration, and mediation shall be formulated. Moreover, the opinions of the Supreme People's Court on supporting and guaranteeing the construction of the Guangdong-Macau in-depth cooperation zone in Hengqin, we call it the Hengqin opinions of the Supreme People's Hengqin opinions, not only proposes to improve extraterritorial law ascertainment and application mechanisms, build a diversified commercial dispute resolution mechanisms, simplify litigation procedures for cases involving Hong Kong and Macau, and strengthen judicial exchanges with Hong Kong and Macau, but also expressly provides that the Hengqin Court shall be supported in applying for being authorized to explore on a pilot basis the extraterritorial law application mechanism and Hong Kong funded, Macau funded, Taiwan funded, and foreign funded enterprises registered in the Hengqin Cooperation Zone shall be allowed to choose by agreement the resolution of contractual disputes based on extraterritorial laws or the resolution of contractual disputes by applying international treaties and international practice and international commercial rules on the premise of not violating the basic principles of China's laws or not jeopardizing state sovereignty and security and public interests. And in September 2021, the CPC Central Committee and the State Council issued the opening up of the Qianghai, Shenzhen, Hong Kong Modern Service Industry Cooperation Zone. We call it Qianghai Plan. The Qianghai Plan proposes to establish an international legal service center and an international commercial dispute resolution center, explore ways to integrate different legal systems and cross-border legal rules, explore the improvement of the mechanisms for applying Hong Kong laws in the Qianghai cooperation zones, and choosing Hong Kong as a place of arbitration to solve civil and commercial cases, explore the establishment of a new mechanism for civil and commercial judicial assistance and exchange between the Qianghai cooperation zone and Hong Kong and Macau, support the Qianghai courts, and exploring ways to expand the scope of accepting foreign-related commercial cases, and support Hong Kong legal experts in appearing in the Qianghai court to assist in the ascertainment of law to protect the legitimate rights and interests of enterprises and individuals engaged in cross-border business investments, and build an international inter-regional commercial dispute settlement platform on which litigation, mediation, and arbitration are independent of each other and coordinated there between. Furthermore, the opinions of the Supreme People's Court on supporting and guaranteeing comprehensively deepening the reform and opening up of the Qianghai, Shenzhen, Hong Kong Modern Service Industry Cooperation Zone not only states that the mechanism for the ascertainment and application of extraterritorial laws shall be improved, and as a center for the settlement of international commercial disputes shall be built. The litigation mechanism for participating in Hong Kong and Macau legal services shall be constructed. Judicial exchanges with Hong Kong and Macau shall be increased, and the exchange channels of judicial talents in Shenzhen, Hong Kong, and Macau shall be expand, but also clearly stipulates that Shanghai courts shall be supported in applying for being authorized to explore on a pilot basis the extraterritorial law application mechanism and Hong Kong funded, Macau funded, Taiwan funded, and foreign funded enterprises registered in the Shanghai cooperation zone shall be allowed to choose by agreement the resolution of contract disputes based on extraterritorial laws, or the resolution of contractual disputes by applying international treaties and international practice and international commercial rules on the premise of not violating the basic principle of China's laws or not jeopardizing state sovereignty and security and public interest. From the above, it can be seen that in terms of resolving interregional civil and commercial laws conflicts in general, the mainland still follows the past approaches, but it's ready or doing some beneficial exploration in the two cooperation zones. First, to expand the application of the laws of Hong Kong and Macau. Second, to build an international, interregional, diversified commercial dispute resolution mechanism and platform. Third, to strengthen judicial assistance between the mainland Hong Kong and Macau. And fourth, to increase judicial exchanges there between. These explorations are both significant and feasible. It is important to note that interregional civil and commercial legal conflicts between the mainland Hong Kong and Macau must be resolved strictly with the constitution law and the two basic laws within the framework of one country and two two systems. On the one hand, the high degree of autonomy Hong Kong and Macau enjoy should be fully respected and firmly upheld. Under the two basic laws, national laws shall not be applied in Hong Kong and Macau, except for those relating to national defense, foreign affairs, and other laws which, according to the basic laws, do not fall within the scope of autonomy of Hong Kong and Macau. This means that Hong Kong and Macau enjoy full legislative powers in civil and commercial matters, thus enacting a unified inter-regional conflict of law or substantial civil and commercial law is not yet feasible. On the other hand, the principle of one country must be upheld, and the integration of Hong Kong and Macau into the country's overall development must be actively promoted. Inter-regional conflict of laws in civil and commercial matters shall not become an obstacle to civil and commercial exchanges between the mainland, Hong Kong, and Macau. In light of this, it's of great practical significance to explore the expansion of the application of Hong Kong and Macau's laws in the two cooperation zones in the GBA to create a legal environment that converges with that of Hong Kong and Macau, and thereby encourages more Hong Kong and Macau residents to live and work in the cooperation zones. Meanwhile, initiatives such as building an international, interregional, diversified commercial dispute resolution mechanism and platform, strengthening judicial system between the mainland Hong Kong and Macau, and increasing judicial exchange there between will also helpful to resolve to a certain extent. Of course, in the future, with the deepening integration of the GBA and the further integration of Hong Kong and Macau into the country's overall development, attempts can also be made to explore how to enact inter-regional conflict of laws through international collaborative legislation. Specifically, the relevant legislative bodies of the mainland Hong Kong and Macau may collaborate in their legislative work, and each specially enacts an inter-regional conflict of laws with constant or mutually harmonized rules. Besides, the three jurisdictions may also try to formulate relevant model laws for adoption by the parties in legislative, judicial, or contractual matters based on the specific circumstances or inter-regional civil and commercial law conflicts. For example, a model contract law that embodies the basic recognized by the mainland Hong Kong and Macau can not only used as a model in their respective legislation, but the contractual parties can also directly choose the model law as the governing law when they conclude contracts to agree on the applicable legal provisions. That's all for my speech, and thank you.
Okay. The vis-a-vis the mutual enforcement and recognition with those for matrimonial cases and also those other cases. My guess is the byproduct will be for shopping and parallel proceedings. Of course, we have provisions maybe both to address parallel proceedings. But my guess is the deeper reason is always the difference of the technical and procedural between mainland and Hong Kong. For example, mainland clients may not be very comfortable with the idea of cross-examination expert witness. In certain cases, they like the idea of convenience fee. They like the idea of third-party funding. I'm wondering if there will be any steps taken by government in addressing the fundamental reasons. For example, in relaxing our bring by way of legislation, or we have campaigns to promote our common law practice, such as proclamation and or employment after witness in Mainland.
You have rightly pointed out that there are provisions as far as the matrimonial and family REJ ordinance refers. There are provisions relating to preventing parallel proceedings. And you also mentioned about foreign shopping. The scheme of the ordinance is that we want parties to have the freedom to choose whether they want to litigate in China, in the mainland, or in Hong Kong. And this ordinance retains that freedom. So it's for the parties to the dispute to plan and organize how would best serve their interests, whether they would litigate in the mainland and in Hong Kong. And they can utilize the ordinance to do the reciprocal recognition and enforcement.
I think we're basically out of time. So if people have other, do 5 more minutes? Okay. All right, other questions? Okay.
Minutes is for myself, so I'm sorry, just joking. The question is, you talk about partly your presentation on finality. It used to be such a huge issue in Hong Kong. So whether Chinese judgment is final, effective. So it seems to me that is no longer an issue, or that will continue to be an issue. Just imagine. I cannot imagine lawyers will not argue the judgment to be enforced is not really final because there's the review process. So how what's the strategy to deal with that particular issue?
Have built in that safeguard. If you want to register a mainland judgment in Hong Kong, you have to obtain a certificate from the mainland court, and the certificate will certify that it is an effective judgment in the mainland. An effective judgment in the mainland under the mainland law means there is no appeal allowed, or if there is an appeal, it has been finally determined. So the certificate would serve as a rebuttable presumption that it is final and conclusive. Of course, it's subject to rebuttable contrary evidence. If the other party can produce evidence that, oh, this judgment is subject to retrial procedure, after the registration application has been lodged, then the other party can produce that evidence as the basis for setting aside. So the main is a simple mechanism. Basically, it's the certificate. If you have the certificate, then it's prima facie evidence that it's final and conclusive.
Other questions? Okay. Well, okay, then thank you, everybody. Yeah, thank you to the panelists.